Is conciliation the same as arbitration? Have you ever wondered how disputes are resolved outside of a courtroom? Today, we are going to clarify the differences between conciliation and arbitration, two popular methods of alternative dispute resolution. While they might seem similar, they serve distinct purposes and operate in different ways. First, let's define both terms. Arbitration is a process where a neutral third party, known as an arbitrator, listens to both sides of a dispute. After reviewing the arguments and evidence, the arbitrator makes a decision that is usually legally binding. This means that the decision can be enforced by law, similar to a court judgment. On the other hand, conciliation involves a neutral third party called a conciliator. Instead of making a decision, the conciliator helps the parties communicate and negotiate. The goal is to reach a mutually acceptable agreement. The conciliator does not impose a solution, which allows for more flexibility in finding common ground. Now, let's talk about the role of the third party in each process. In arbitration, the arbitrator has the authority to issue a final decision. This makes arbitration more formal and structured, resembling a private trial. The arbitrator controls the process and follows specific rules. In contrast, the conciliator acts as a facilitator. They guide the parties through discussions and encourage collaboration. This process is generally less formal, allowing the parties to have more control over the outcome. Another key difference is the legal binding nature of the outcomes. Arbitration results in a legally binding award that can be enforced in court. Conciliation agreements, however, are not automatically binding. The parties must voluntarily formalize their agreement into a contract for it to have legal force. When it comes to the nature of the process, arbitration tends to be adversarial. Each party presents their case, and the arbitrator decides the dispute. Conciliation, on the other hand, is collaborative. It focuses on restoring communication and preventing disputes from escalating. In terms of practical applications, arbitration is often used in commercial disputes, construction contracts, and labor issues. It is particularly useful when enforceability is important. Conciliation is more commonly applied in family disputes and community conflicts, where maintaining relationships is a priority. Lastly, regarding legal representation, parties in arbitration typically have lawyers to present their cases. In conciliation, legal representation may or may not be present, as the process is more informal and accessible. Understanding these differences is essential for anyone interested in legal education and specializations. Conciliation emphasizes negotiation and voluntary agreements, while arbitration provides a binding resolution. Both methods play important roles in alternative dispute resolution, catering to different needs within the legal system.